Susan.
Good morning, members. We've got the quorum, and I'll call the meeting to order. Item 1, confirmation of minutes of the last meeting. You should have received a copy of the minutes, and the clerk hasn't received any proposals for amendments. So shall we confirm the minutes? Agree? Yes. Item 2, information paper issued since the last meeting. You should have received the information paper. The clerk has issued the information paper, which has been attached to the agenda. Any questions? If not, then next meeting. Items for discussion at the next meeting. The next meeting will be held on the 16th of December. This is not the regular time slot, Monday morning, because of Christmas holiday. So that's why we changed it to a Tuesday afternoon. The administration has proposed the following items to be discussed in the next meeting, and that includes subsidiary legislation to implement International Maritime Convention and also annual tariff reviews with the two power companies. Do you agree that these two items be discussed? All right. Well, on that day, the time planned for holding the meeting is 5:15. I will work with the clerk to see depending on the availability of meeting rooms, to advance the meeting time to start at 4:30 p.m. Is that all right? Do you agree? Yes, agree. All right. The next item then is subsidiary legislation proposals under the Competition Ordinance. So shall we invite the administration team in now? I don't think I need to introduce them one by one, as you are all familiar with them. First of all, welcome the government officers. Perhaps I would now like to call upon the Permanent Secretary to take us through the paper. Thank you, Chairman. We are very happy to attend the meeting of the EDP to take members through the paper on the subsidiary legislation proposals under the Competition Ordinance. Since the enactment of the ordinance, the government has been working with the Judiciary and the Competition Commission to do preparatory work for the full commencement of the ordinance. And the Judiciary is now drawing up regulations and rules on the operation of the Competition Tribunal. And then for the next item, the Competition Commission will be taking members through the draft guidelines. Now, we propose 3 subsidiary legislations to be made under the Competition Ordinance. Let me take members through the 3 pieces of subsidiary legislation. The first one is the regulation to apply the key provisions of the ordinance to 6 statutory bodies. The Competition Ordinance does not apply to a statutory body. The key provisions concerned relate to the competition rules, enforcement powers of the Competition Commission, and enforcement before the Competition Tribunal. When we drafted the legislation, we already told that the electrical that 6 statutory bodies will be covered under the ordinance, including Ocean Park Corporation Federation of Hong Kong Industries, the General Committee of the Federation of Hong Kong Industries, Matilda and War Memorial Hospital, Kaduri Farm and Botanic Garden Corporation, and the Helena May. These 6 corporate statutory bodies will be covered under the ordinance. They are engaged in economic activities, and their economic activities are not directly related to public policies. So on these proposal, we have already consulted the 6 bodies, and taking into account their feedback, we think that the conditions for applying the key provisions of the ordinance to these bodies continue to be valid. So we suggest that the CE in Council make the subsidiary legislation. As for other statutory bodies, when we passed the Competition Ordinance, we undertook that after 3 years, after the Competition Ordinance is implemented, we then will make a review. Now, the second piece of legislation relates to the regulation to disapply the key provisions of the ordinance to bodies which are not statutory bodies. There is a mechanism within the ordinance to disapply the key provisions of the ordinance to certain bodies. Now, after we have conducted in-depth study with policy bureaus based on public interest considerations, we propose to disapply the key provisions of the ordinance to bodies covered under the SFO 571 cap, and that include RCEs, RCH and RXC. RCECs include Stock Exchange of Hong Kong Limited, Hong Kong Futures Exchange Limited. RCHs include Hong Kong Securities Clearing Company Limited, Hong Kong IV Clearing Corporation Limited, the SEHK Options Clearing House Limited, OTC Clearing Hong Kong Limited, and for RXC, Hong Kong Exchanges and Clearing Limited. RCEs, RCHs, and RXC are important financial market infrastructures. They have statutory duties to discharge under the SFO, and they need to operate under a high degree of legal certainty. And they should, as far as practical, ensure orderly, informed, and fair market in securities and futures dealings. So they play a very unique role in these markets. And the SFO also requests that in discharging their duties, that these bodies, when ensure that the interest of the public prevails where it conflicts with their interest. Under the SFO, there is a specially calibrated regime for regulating the securities, futures, and derivative markets. The SFC is the regulator of these markets, and it has a clear monitoring role, and that is to offer an orderly, informed, to promote the fairness, efficiency, competitiveness, transparency, and orderliness of the markets. And they should also take into account the competition factor in their monitoring work. Now, there should be sufficient competition among persons operating in the market. And also the SFO also empowers the SFC to ensure that the RECs, RCHs, and RXC will not engage in non-competitive acts. For example, their rules should be approved by the SFC to maintain financial stability and to manage the systemic risks. We must ensure that these bodies should operate under a high degree of legal certainty. So we propose that the CN Council should make subsidiary legislation to disapply the provisions, the key provisions of the Competition Ordinance on REX, RCH, and RXC. Such a disapplication approach will not change their status as undertakings, and their partnerships with other undertakings would also be subject to the Competition Ordinance. And we believe that our proposal has already struck a good balance. Third piece of legislation is the regulation to be made on turnover of undertakings. We suggest that the Secretary for Commerce and Economic Development make a regulation to provide for the determination of the turnover of an undertaking. The turnover of an undertaking is used to determine whether they can be subject to enjoy the exclusion of agreements of lesser significance and conduct of lesser significance, and also to calculate the pecuniary penalty imposed in case of a contravention. We want to clarify certain technical issues in relation to the ordinance, and it doesn't have to do with the original provisions of the ordinance or undermine them. Now, we have taken reference from the Hong Kong accounting standards and overseas competition laws in coming up with the regulation proposal, and we aim to clarify the following points. A, for the purpose of exclusions under agreements of lesser significance and conduct of lesser significance, the undertaking refers to the undertaking's ordinary activities, whether in Hong Kong or outside Hong Kong, after deduction of sales rebates and taxes directly related to turnover. And also, for the purpose of determining the cap of pecuniary penalty, the turnover of an undertaking will be confined to that obtained in Hong Kong. In practice, it will include sales of an undertaking to customers in Hong Kong, as well as export sales made from Hong Kong. The regulation will also clarify that in case an undertaking consists of 2 or more undertakings, that each prepares accounts, the turnover of the undertaking concerned should be calculated by adding together the respective turnover of each. But that the turnover arising from intergroup transactions would be excluded. So, Chairman, so much for my presentation. So, if members have any questions, we'll be more than happy to answer them. Thank you. P.S. Those who have indicated their wish to speak is Chan Kam Lam, Sin Chung Kai, Kenneth Leung, Andrew Leung, Christopher Chung, U.C. Wing. Any others? 4 minutes each then. Chan Kam Lam. Thank you, Chairman. The paper discusses 7 bodies which are in the financial market, including REACs, RCHs, and RSC, on the disapplication of the key provisions. I agree with the proposals. These bodies play a very unique role in Hong Kong's financial market. If the key provisions disapply, well, then we must strengthen our supervision under the SFO on them, or else, well, we will attract criticisms. Well, after all, they are not the only clearing or settlement houses. So in order to avoid criticisms, we should strengthen monitoring on them. We have what they are sort of involved in some conflict of interest within the market. So for the Competition Commission and the SFC, there should be good guidelines drawn up to ensure that in their day-to-day operations, they would not be sort of dominating the market. Also, I support the regulation to be drawn up to determine or setting out clearly the how turnover of undertakings should be calculated. For SMEs in Hong Kong, then these regulation will make it clearer to them, and so that they would not be caught inadvertently and then penalized.
So the DAB agrees to the 2 proposals. The Permanent Secretary. Now the SFC and the Competition Commission will communicate on the regulatory work. Now, on stepping up the supervision, I asked my colleague to supplement. Ms. Selina Yan, right now, the 6 undertakings. Now, the internal charter requires them to get approval of the SFC, and the SFO provides for the vetting by the SFC. When these rules are established, the public and the market's views have to be sought. That's one aspect of the supervision. We agree with Mr. Chan's proposal that in implementing the requirements regarding competition under the SFO, the SFC and the Competition Commission will strengthen their communications, and in the past months or so, the officers of both organizations have communicated with each other to understand the daily work of each. Mr. Sin Chung Kai, 2 questions. Now, the securities industry always complain that they are regulated by 2 supervisors. That is, the FFC regulates non-banking securities business, and the Banking Commission regulates the securities activities within the banking industry. Now, I understand that there has been a memorandum of understanding signed between the 2 bodies to prevent overlapping. Now, your document didn't mention this, and the legislation doesn't provide that way. Now, the SFC as a regulatory body hasn't signed any memorandum of understanding with the Competition Commission. Now, you have now made these exemptions under the conduct rules, and you say said that the SFC has been authorized to vet these matters. Now, there is no memorandum of understanding, and I think the SFC, as I remember, it was enacted around the year 2000, and at the time there was no anti-competition efforts, and so these factors were not considered. Now, when the Competition Ordinance is in the process of being introduced, then the Competition Commission hasn't gone through the SFC to see what needs to be changed so that there is a legal basis for the SFC to do what it should. Now, the Secretary, now, we are not saying that the the main provisions of the Competition Ordinance would be implemented by the SFC. We are saying that the 2 trading platforms and 4 exchange clearing companies and the 1 out and controlling exchange controller should be exempted because they are already supervised by the SFO. So the member said, do we need an MOU? We can go back and look at that, but it's not that we are asking the SFC to implement the relevant provisions under the Competition Ordinance. Selina? Now, concerning the second question by Mr. Sin, he said that the SFO doesn't include a clear objective on competition. Now, I perhaps can quote from the SFC. Indeed, there is that objective that has been allowed for, because when the SFO was drawn up, the electrical members were far-sighted enough to insert that objective. Now, the SFC, apart from having to promote the effectiveness and the transparency of the market, now under Section 62C, it states clearly that when it supervises, it will try not to be in the way of the SFC supervising the competition among the entities. Now, also the HAX and the bodies under it, and under the SFO, it says that apart from being a market operator, the exchange has to place forefront the interests of the public, especially when there is conflict with the interests of the company. The public's interest has to be overriding over its own commercial interests. So this is very close and consistent with our competition objective. Mr. Leung Kai-cheong, Kenneth Leung. Now, the Secretariat prepared a document that is CB bracket 4 166 4015 bracket 04. Now, I want to refer to paragraphs 8 and 12. They listed that based on a given public interest, the administration supplies the main provisions from certain non-statutory bodies, and the administration now wants to pass a sub-legislation to for this effect. Now, I can understand about the recognized exchanges, but the clearing houses, they are ordinary commercial businesses. Why do you exempt them? Now, you talk about public interest. Now, public interest is very wide, and it's sometimes misused concept. Now, what guidelines do you have for exempting them? Now, the second question is rather more technical. It's about para 12. Now, the turnover of the undertaking. Now, there are two different ways to delineate that. One is under 200 million, and the second is under 40 million. Now, the 200 million and 40 million figures, how do you come up with that? And would you regularly revisit these two numbers to see if they are still appropriate? Perhaps I will answer the second question first, and then I'll ask Selina to answer the first one. Now, these two figures, when we drafted the bill, I recall that the Census and Statistics Department made estimates of the turnovers of SMEs. So these two figures are now in the main legislation. And back then we said that we will, from time to time, review these two figures. Now, of course, the principal legislation has just been enacted. The ordinance has not yet come into effect. We have to submit these few pieces of legislation, and the tribunal and the CC have to complete their work before the ordinance comes into effect. Selina, now Mr. Leung pointed out that regarding the four clearing houses, they fulfill very important market functions. That is, behind the trading platforms, they are fulfilling, clearing functions. Now, this has a lot to do with the risk management of the securities market. Now, they are important infrastructures for risk management. So we think that these clearinghouses should be exempted. Now, under the SFO, these recognized clearinghouses, RCHs, the functions require that they take into account the interests of the public in the way they operate. Now, on the interest of the public, perhaps I can say that they're in two respects. Firstly, we must maintain the stability of the financial market, and therefore at the RCHs and the REXs, they play a major role. And we have to consider the overall development of the market, and that's also in the public interest. Mr. Andrew Leung, first, I have to declare that I'm a member of the Competition Commission, and also I represent Industries 1, that is the Federation of Hong Kong Industries. Now, this paper covers them, covers the Federation of Hong Kong Industries. Now, there are 4 conditions that have to be met for them to be, for one to be exempted, and not all 4, however, are fulfilled. Now, the FHI under Cap 321 was established as a business association, and in the board, on the board, 3 directors are appointed by the administration or by the government. One of them is a senior official of the Industry and Commerce Department. So very often we act according to the industrial development policies of the government. Now, so we liaise with the government in implementing industrial policies, and now the HKI has a commercial element, but very often that is linked to the government's public service. So the HKI has asked me to spell out the reasons. The Secretary. Now, we already communicated with the organizations concerned before we drafted the regulation. We understand the stance of the FHKI. We understand the feeling why they think they should continue to be exempted. Now, 5.2 of the ordinance lists there are 4 considerations that have to be met before the relevant organization can be exempted. And we feel that although the FHKI right now they provide a lot of services for the industry, and many of these services have to do with business operations, and they provide training courses and consultation service. And when the administration considers that case, we don't feel that these are the principal public services as mentioned in the ordinance. So we think that the FHKI and the board of the FHKI should be regulated under the ordinance.
When you say you don't agree, you mean that is it the administration who doesn't think that there is a need to exempt them, or do you think the public opinion is that way? Well, we actually have communicated with the FHKI, and the ultimate decision has to be based on the provisions in the ordinance, and that is the 4 considerations listed under Section 5.2. If these conditions are not satisfied, then we believe that the it should be put under the regulation of the ordinance. Mr. Christopher Chung. Thank you, Chairman. I first have to declare I'm engaged in the securities industry. For the Competition Ordinance, well, in fact, in paragraph 10, it says that the SFO, there is already provision stating that whatever fees that are to be imposed by the bodies, they are subject to certain SFO regulations to ensure that there is competition. The SFC, from our past, or rather the Hong Kong Exchange, is very keen in doing business, and we ask them to review their fees. Every time their reply is that they have to uphold the interest of the shareholders. And they are very keen about making profits. And it seems to me that it is just a private company aiming to maximize profits, and it's not like a public body which tries to protect public interest. So if Hong Kong X and the two or the four clearinghouses under them are exempted, how can the administration ensure that these bodies will discharge their social responsibility, and to ensure that the small and medium-sized market players can also participate in the market fairly, and how to ensure that they charge in a fair manner as well? Selina. Thank you, Mr. Chung. We must point out that this time we propose that these bodies, including HKXE, be exempted from the key provisions of the Competition Ordinance. The key is really not to ask them not to promote competition or putting them totally outside of the Competition Ordinance. What we are saying, in fact, is the reverse, that they should aim for competition in their day-to-day operation. And the SFC, as we quoted before, in discharging their monitoring role, it should also consider the competition among those which are being supervised. So this is a requirement under the law, and the SFC has to consider that. Of course, there are other factors to be taken on board, including the stability of the market, efficiency, and so on, and also the overall competitiveness of Hong Kong. These are the other factors it has to consider. Now, Mr. Zhang mentioned about the fees charged by Hong Kong X. Now, under the SFO, there are clear stipulations empowering the SFC to monitor the fees of HKX, and that they should also have regard to the competitive factor. And that is divided to two parts: internal competition within Hong Kong and also competition with overseas partners. So this is something that the SFC must consider. Every time there is a change in the fee, the SFC has to consider these factors, and these are required under the law. So as far as we understand, in their daily operations, the SFC will every time ask for response from the HKX if there is an application or change in the fees, and information relating to competition in Hong Kong and overseas should also be provided to SFC. We, of course, also encourage the SFC in the future to strengthen dialogue with the competition, and they can learn from each other. Would that have an impact on the SMEs? Because Mr. Chang asked a question on how you can uphold the interest of the SMEs so that they should also be competitive. Chairman, since the HKX is closely monitored by the SFC under SFO, and then there are 6 board members appointed by the government on the SFC. C board. Well, if that is the case, why do you still ask for exemption? Well, Mr. Zhang is very right. The 6 units and the Hong Kong X come under the present securities monitoring mechanism. So that's precisely because the issues concerning competition can be adequately dealt with under the SFO, so there is no need for the competition ordinance to cover them, or else we'll be ending up with certain instability as far as legal provisions are concerned. Your question about the SMEs, their competitiveness, well, we attach a lot of importance to that. Mr. Zhang may well know that we regularly hold meetings with the trade, and we try to understand the problems they are facing. And we will continue to do so. And we also encourage the Hong Kong X and its associated bodies to step up their communication with SMEs in the industry and try to help them out with the problems they face. So this is something we would strengthen in doing. Mr. Yu Si-wing. Thank you, Chairman. I would like to discuss paragraph 4 in the paper. The key provisions will be applied to 6 statutory bodies. They will be subject to the Competition Ordinance. My first question is, under what circumstances will other statutory bodies which are not subject to the ordinance will be subject in the future? We've now got 6. Will more statutory bodies be added to the list? Under what circumstances will you do that? Second question, I would like to raise a question about paragraph 8 and applying the key provisions to Hong Kong X and other RECs and RSHs. The government's justification is that is public interest grounds, and also they have already been subject to rigorous scrutiny already. So does it mean that if there are certain bodies applying in the future for exemption, should they just be securities or financial bodies? And is it the case that when they can meet with their criteria, like they have public interest grounds and they are subject to rigorous government scrutiny and supervision? I mean, if once these criteria are met, then they can apply for exemption. And if their application comes forth, what other criteria would you consider in granting them exemption? Statutory bodies first. When we drafted the bill, the government actually conducted a very comprehensive review on the 500-odd statutory bodies in Hong Kong. And back then, we identified 6 statutory bodies which do not meet with the exemption criteria. So actually, the administration has taken a review of all the statutory bodies already. And we've made the decision that only these 6 statutory bodies will be subject to the ordinance. That's the first question. Second question, in the ordinance, the government is empowered through approval by the CEN in Council to disapply the key provisions of the ordinance to bodies which are not statutory bodies. Now, as to whether we would exercise that power, well, the government will tread very carefully. As what we said in the paper, unless there is a great public interest or the fact that certain bodies, like this case, they are the important market infrastructures, and on those grounds, we propose that these 7 bodies be exempted from the competition ordinance. We have already When we did that, we have already consulted all the policy bureaus on this, and ultimately we identified these 7 bodies which needed exemption. And at this juncture, the government doesn't have any other proposals to exempt other non-statutory bodies from the ordinance. Well, Chairman, if there are undertakings which may meet with these criteria, is it the case the government will not consider exempting them at all? Well, of course, if an undertaking or body wishes to apply for exemption, the body can write into the administration to ask for exemption, and upon receipt of such a proposal, we will study it. But as I said, we have examined all types of bodies under various policy bureaus to see if they are meeting with the exemption criteria, and our conclusion is that there are no others apart from the 7 identified in the paper. Mr. Tan Ka-pil, 2 questions, 1 short and 1 long. Regarding the exemption arrangement as proposed in this paper, well, even if the parent company is exempted, the subsidiaries may not get exempted if they are registered separately. All right? For some statutory bodies, they may be charitable bodies which have a long history, and well, they like to now embark on setting up social enterprises. Now, if they do that, will they be exempted from the Competition Ordinance? How do you draw the line? That's number 1. Number 2, in the agreement between 2 undertakings, there is a question of turnover. Hong Kong, doing businesses in Hong Kong is very easy, and people may just like to set up a shell company to sort of be entering into an agreement, the original company. So how will you deal with them? Now, I watched television earlier. Well, there was just this case. Tour guides, they now, their main income is from tips from clients. Now, how do the level of tips normally be drawn up? Well, it's normally drawn up by the TIC. So if you calculate turnover in the future, do you just calculate the income of the travel agent, or do you also take into account the tips received by the tour guides? 2 questions. Subsidiary companies.
Now, on subsidiary companies, now there are some statutory bodies that are subject to regulation. Now, if they have some business that is undertaken by the subsidiaries, the exemptions don't apply to the subsidiaries. Now, the ordinance is clear on what is a statutory body. Now, on the setting up of shell companies or virtual companies, and now it depends on the actual case. Now, if the future commission is to investigate some non-law-abiding behavior, they will look at the company concerned, and that company may be not just the subsidiary, but it may also include the parent company, and depending on the case, of the facts of the case, they will determine whether only the subsidiary company is involved or whether there are other companies in the group. Now, on the determination of the turnover, now here we have the criteria for determining the turnover as to whether we should, in that specific case, look at the turnover of the company, subsidiary company or the parent company. It depends on the actual case. Now, on the matter reported in the newspaper yesterday, now if we or reach a decision on the tips. Now, do you count the tips received by the tour guides, or the also the part received by the tour agency? Now, it depends on the actual facts of the case. I'd like to ask the Permanent Secretary. Now, the Competition Ordinance, since it has been discussed, now on the exemption of public organizations and statutory bodies, there have been different views. Now, we have heard members speak about different industries, and they have submitted their views to the government. Now, we have seen that many statutory bodies have functions that concern important housing government policies like housing, industrial development, and so on. So if they are not exempted, some people feel that the functions might be affected. Now, one concern expressed is that if there's a project which involves public and private participation, and in the course of business they infringe the Competition Ordinance, and the public organization is exempted but not the private business. So how do you avoid this embarrassing situation? Now, if in future statutory bodies are set up, and some of them may be involved in economic activities, in that case, how does the government decide which would be exempted and which will not be exempted? Now, Chairman, of course, the exempted statutory body still has to follow the law. Now, when we discussed the bill, we explained to the committee, the Bills Committee, that even though these statutory bodies are exempted, now in the future there will be mechanisms in cases where these bodies engage in law-infringing behavior. Now, of course, we have a consultation committee to the Competition Commission as chaired by the Financial Secretary, and that body will investigate the complaints regarding competition. Now, these are statutory bodies. Now, they may provide certain public services or engage in public policy. So will they in fact be engaging in law-infringing behavior? Now, the government will work through this supervisory mechanism to ensure that these statutory bodies do follow the competition principles. And I believe that's the way we'll deal with that in the future. Now, on new statutory bodies, now if we find that these new statutory bodies likewise do not fulfill 5(2), the 4 conditions therein, then we will apply the same approach as we did in the sub-legislation, and we will disapply the exemption. Now, Mr. Christopher Cheung, 2 minutes. I will draw the line here. I'd like to ask the administration. Now, in paragraph 9 of the document, it says that it wants to maintain stability of the financial market. Now, somebody might engage in cutthroat competition and operate at very low cost to force other business into losses. Now, does that constitute an infringement of the Competition Ordinance? Celinda? Now, the scope of this application that we talk about today is the Hong Kong Stock Exchange and the clearing houses concerned. Now, for other bodies or undertakings, or now the competition will apply to them. So when the SFC undertakes supervision, it will look at these operators if there is inadequate capital in the way they operate, causing risks to investors, or they operate in such a way that they cannot provide normal service, then the SFC will ensure that they have sufficient capital. So if they engage in cutthroat competition, can they maintain that practice? The SFC will consider that. The market participants are not exempted from the Competition Ordinance. Now, if these are market participants, they are under the ordinance. I'd like to ask one more question. Now, the securities business currently is not separated from banking business. Now, that already constitutes unfair competition. Has the government considered improving that? That is a matter of possibility, Selina. No, actually, we are concerned about this. Now, of course, the bank is engaged in securities business. It has to get a license of registered institute from the HKMA, and the ASFC cooperates with the HKMA to ensure that they supervise at a similar level and strength. So members have provided many opinions, so I hope that members will take note, and if there's a need to make amendments or improvements, then you should deal with that. I'd like to ask members, do we agree with the three pieces of sub-legislation submitted by the administration today? We all agree. Chairman, we've heard the members' views, and we will go back and draft the sub-legislation, and we believe by early next year we will come back to LegCo. Thank you for attending. Next item of agenda is draft guidelines made under the Competition Ordinance. First, we invite the representatives to join us. We have with us many officials, and the names list is on your table, so I will not read the individual names and positions. First, we welcome Ms. Anna Wu, Chairperson, and your large group of team members. Now, the Competition Commission will brief the panel on the work of the Commission now and the consultation undertaken. Now, the Competition Commission will consult the LegCo after it receives the comments from the public and the industry before eventually the draft guidelines will be promulgated. Now, we welcome you all. Now, apart from representatives from the Competition Commission, we also have representatives from the Office of Communications Authority. Now, Madam Wu, can you take us through the paper? Good morning. This is the second time we come to this panel to brief you about our stage of work. The consultation is in 2 stages. The first engagement exercise starts in May, and at that stage we discussed with the stakeholders, and the second stage begins on December the 9th. It starts with the 6 guidelines that we issue. Now, I will explain to you that it's a joint document with the Communications Authority because these 6 documents will be jointly used by both organizations. Now, there are 2 groups. The first group concerns the 3 conduct codes and conduct rules. These are refer to collusion and merger and so on. And the other 3 guidelines concern procedures, complaint investigation, and exemption procedures, and how we will deal with these. And in the first stage of consultation, we received information from everybody concerned, and a lot of these will be incorporated in the drafting at the second stage. And for example, at the second stage, in these 6 guidelines, there will be many hypothetical examples. These have been requested from the industry. They want more explanation to be put in a manner easy to understand. And we have also provided targeted discussion on certain issues. For instance, on the explanation, what are our analytical tools? There are many notes on that. And there are examples on the exchange of information under what conditions will there be collusion in pricing and so on. And there's also targeted discussion on the transfer price in retail price setting, and also what is market power, what is market, and so on. Now, these have all been focus points in the first stage, and so we pay more concern to them at the second stage. And what will we do next? Firstly, we will promulgate a set of tools for assessing SMEs. This will help the SMEs to have a better understanding, and we also will introduce a policy paper on the lenient treatment.
So this paper is not actually required under the guidelines, but we think we need to be set out clearly how we deal with leniency agreement. The third set of document will have to do with the priorities in enforcing the law. It is not required, so to speak, under the law, but then we feel that we need to explain clearly to members of the public our priorities in enforcing the law, how we see which areas should be tackled first and so on. So we hope that helps. And the last document, well, I think it's an important document, that is a memorandum of understanding between us and the Communications Authority. We are drafting the document now, and we will take and submit the paper to the electoral members and consult your views. And in the next few months, we hope to complete these several documents, and by early 2015, we hope to be able to present these documents. Especially the finalized guidelines can be submitted to the electrical members for reference and for you to give us further views. Thank you very much, Chairman. Mr. Tan Ka-Piu. Thank you, Chairman. The Competition Ordinance is taking shape, and we envisage that it will take effect next year. But as a representative of the labor sector, I'm a little bit worried because the Competition Ordinance may do harm to the workers. Now, 2 examples from me. In the construction industry, for the past several decades, the construction industry associations and the contractors association have been engaging in negotiations, and such negotiations will be within the scope of the Competition Ordinance. But personally, I think the economic policy should be separate from labor policy. So what is your stance on this case that I mentioned? The chairperson said that there will be some leniency arrangements. Perhaps in terms of priority, you would put labor down on the list. So I would like to know your stance. There are sort of negotiations going on between the labor associations and also employers associations, and they may cover, say, the construction industry, catering industry, and so on. So if they fall under the scope of the Competition Ordinance, then that would be a problem. Now, next, there has been a news report yesterday, in fact, that the tour guides' main income comes from their tips. And the tips was sort of fixed by the Travel Industry Council. So how do you deal with them? Do you count those as part of the turnover of the undertaking? And what is your stance? Yes, perhaps I'll defer to the Operations Executive Director, Mr. Timothy David Lear. Well, perhaps you can take those questions.
Yeah.
Thank you. Sorry, waiting for the translation. Well, thanks very much for the question. First, competition laws are concerned with the behaviour of enterprises competing for customers. And the honourable member's right. It's not normally the focus of competition laws to look at labour laws and industrial relations. And worldwide there are a number of specific exclusions, but there's not a specific exclusion in Hong Kong. But while there's no express exclusion, it's the Commission's view that employees are unlikely to be undertakings for the purposes of the ordinance, and that negotiations undertaken on their behalf by unions means that they're also unlikely to be considered undertakings in that role where they're negotiating with an employer. There are some grey areas when it comes to large employers collectively negotiating with employees, but there are a number of factors which need to be weighed up to determine whether such conduct is anti-competitive, including whether those negotiations result in fixed or recommended wages and the possible inefficiencies involved. And the Commission's in dialogue with union representatives and is also considering whether it would be helpful to provide some additional guidance to clarify that issue. On the issue of tour guides and whether tips would be included or excluded, it's really a question of fact we'd need to look at. I can't answer that on the specifics of this moment, but in terms of determining what the undertaking's turnover would be, they may be a factor, but I don't know.
My question is, if the tour guide is clearly an employee of a travel agent, will that help? Now, because some unscrupulous travel agents are asking them to be self-employed people. If they are clearly the employees of the travel agents, then would that help clarify the situation?
It's okay. Time for translation.
Again, it depends what you're asking about, whether it's the employees involved in some kind of misconduct or whether it's just the fact that they're part of a system with the travel industry. I think the key thing to say here is we're in dialogue with the TIC on various issues, and this may be one of them. We saw the press yesterday. It's something we should talk about.
Next, Mr. Dennis Kwok.
If I asked in English. Thank you, Anna, for coming here again to update us on the guidelines, and congratulations to the Commission for doing the draft so quickly. My questions relate to some of the comments which my colleagues in the legal profession have filed with the Commission regarding the draft guidelines. One is from Allen and Overy, and I think they raise a good point about the draft guideline on complaints and whether the Commission can provide more detailed guidance on the types of complaints the Commission will investigate and those it will not, because they note that the Commission has very broad discretion in this area as to when it will investigate and when it will not. And they are thinking that perhaps more detailed guidance, setting out the exact criteria under which the Commission will exercise its power to investigate, would be very helpful for the public. The other good point which I see that's been raised by Freshfields in his submission is at paragraph 5b, where it talks about setting guidelines for international best practice, because for big multinational companies, they are of course familiar with dealing with competition regimes around the world. So competition law itself is not new to them, but they would like to know how that interrelates and work with the other international regimes on competition law. So basically, the international best practice guide would be used as sort of a bridge between the different jurisdictions, connecting Hong Kong with other jurisdictions that also has competition regime. So those two questions I'd like to invite for comment. Thank you.
Anna, would you like to answer?
多謝主席. If I may firstly invite Philip to discuss the point on complaints, and if I can invite Rose to follow with international best practice.
Mr. Monacan.
Thank you for the question, Honourable Member. It is the case that a number of the submissions we've received have questioned this issue of our discretion to investigate complaints and whether we have a broad discretion or whether it should be narrower. We've given some indication of the factors that we would look to in prioritising complaints already in the draft guideline on complaints. And I think possibly what I would say here is we will, it's an ongoing consultation. We'll look at those factors and consider whether there's a need to supplement as required. The second question, and maybe I just make a brief remark on it, we have endeavoured to follow international best practice as a matter of course, I would say, and I would think our approach is consistent across the board with international best practice, and from that perspective, companies that are familiar with competition law as it operates in other jurisdictions, whether that's the US, whether that's Europe, whether that's down in Australia or elsewhere in Asia, should be familiar with the approach we're taking, and I would say that there should be no surprises in terms of our interpretation of substantive issues.
On the guidelines to investigate, so is the Commission going to set out more criteria, giving very clear sort of circumstances or factors which it will consider whether or not to investigate a particular case?
Mr. Chairman, can I invite Tim to supplement that particular question, please?
Tim.
I'll get buzzed again.
It's okay.
Sorry, there's two parts to that. The first is we as we indicated it, as Anna indicated in the opening, we're intending to release enforcement priorities close to the date in which the ordinance comes into effect. So that's something to look out for in terms of understanding how we will go about exercising our discretion. But the other part is we are listening to what people are saying as part of the consultation process, so we still have to go through, consider what they've said and see whether or not it's appropriate for us to provide further guidance and in what form.
Okay. Rose.
Just to follow on in relation to international best practice, the other thing I would mention is that the Commission is a member of the International Competition Network, and we're working closely in a number of their working groups. That organisation is aiming to cater for the issue that people are working in many jurisdictions, and to the extent that competition law can be harmonised, we will be working as part of that network. Of course, so we have to take account of the particular issues under the ordinance in Hong Kong and also the Hong Kong market as well.
蔣麗芸議員，
唔該主席。
或者我讀一讀因為正話我開始嗰陣時得一個。
Okay, let me read out the names of the members who would like to raise questions. Dr. N. Cheung, Sin Chung Kai, Chung Kwok Pan, and Mr. James Tan. Dr. N. Cheung. Thank you, Chairman. I heard Mr. David Lear's reply, and he said that for labour issues, they may not be sort of dealt with by them, and labour issues may not have anything to do with business activities. So I'd like him to make clarification on that. Well, to my understanding, the Competition Ordinance covers mainly business activities. Now, if we talk about labour issues like pay rise, then they should not be covered to my knowledge. So I want a clarification on that. Anna also said that there will be guidelines of different on different aspects. Is it the case that there will be a set of guidelines on complaints and investigations? Are these the target groups of these guidelines members of the public? Now, I must say that the SMEs are not very familiar with the ordinance, and also the members of the public are not also clear about under what circumstances they can lodge a complaint. So I hope that the complaint guidelines can use layman language so that the members of the public will know exactly what they can do under the law in terms of complaints. And also, just now, I received a request from a friend, and
the question was in English, so I will also speak in English.
Accountants Association does issue a suggested fee scale for members. Would it amount to offense? This is first question number one. And the second question is, accounting firm requires a withdrawal partner to avoid entering into another firm for 2 years after resignation. Would it be an offense?
好，邊位答呢？
主席，
Now, Chairman, just now my colleagues provided some answers on several questions. Now, Anne asked this question again, so I'd like to answer again. Now, concerning trade unions, the collective bargaining or collective representation, now we see 3 points. Now, firstly, whether it's a business entity. If it's not, then it wouldn't be considered. Secondly, would it be an economic activity? That's what Anne referred to. Now, is that what we normally refer to as commercial activity? In general, we think that it isn't. And thirdly, on policy, we have to draw the line or delineate. Now, labor policy is very different from competition policy. So any bargaining on labor matters, we will not deal with them with priority. So I hope that makes things more clear. In the future, if necessary, we will make further clarifications on our website or in written publications. Please allow me to continue. Now, as for complaints, how do we deal with complaints? Now, just now, we heard the needs expressed, we will dedicate our effort. Now, on our website, there is a lot of information with some APIs. I've seen them. They are quite well done. Please take a look at them if you can. Every time we go on a promotion, we bring along the APIs with us. Now, on complaints, now, actually, in the end, it should be looked at with our two investigating functions. Now, of course, we place importance on cases where it concerns the public more and where the policy is more major. Now, the complaints are sometimes they provide their names and sometimes they are not, so we will deal with them. Now, okay, I will, concerning the Accounting Association fee guidelines, Now, actually, on accountants or other professional bodies, on their fees, now, if there is an agreement on the fees, now, in general, we feel that infringes the first conduct rule, and we have been discussing actively with the professional bodies. Now, if it's just a suggested price or fee, you can see that this is discussed in our guidelines. Now, if it's just suggested and it's not binding, in general, it's permitted. Now, the suggested price, if it's not in effect a suggested price, but in fact there is pressure on people to accept that fee, then this will fall under the first conduct rule. Sin Chung Kai? No, actually, I don't really have a question. Now, the ordinance hasn't yet come into effect. Now, according to the short title and the commencement date, the Secretary for Commerce and Economic Development has to gazette the commencement date first. So the consultation is important. Now, assuming that Madam Chair can sort out all the issues, hopefully most of them, then when the administration or the Secretary tries to implement them, that there won't be so much pressure. Otherwise, it comes to LegCo and we will get a lot of objections. Now, para 17 and 18 mention that you are doing some work internally. Now, on your guidelines, now I don't know how you, in what ways do you try to make sure that people will think they are okay. Otherwise, when they come to LegCo, they will object and say that it can't be put into effect. Now, how do you prevent this kind of possible crisis? Don't try not to leave everything to LegCo, because we cannot guarantee that everything can be passed. Now, this is a very practical issue. I accept that there is a need. On this, we have to work further. Now, firstly, our publicity education will continue. What does that include? Risk assessment. Hopefully, there will be very practical and simple ways to help the SMEs to reduce the problems for them. And secondly, we talked about international standards. Now, there are many international companies in Hong Kong who are already following these procedures, because the spirit of procedure is broadly followed in all jurisdictions that have competition laws. So most businesses already follow them. Now, on the third point, now we will discuss hard with the government now on whether at the policy level, especially on competition policy, some of them needs to be taken forward by the government, some has to be taken by us. So it's about statutory bodies. We hope that we can discuss with them how to implement the policies, what will be the meaning of the policies, and so on. So we will work in these three respects. Chung Kwok Pan. Now in the draft guidelines, now Part 4 and Part 6. Now Part 4 says that when the Commission receives these complaints, firstly it is a direct complaint. Secondly, the name is not provided, and then thirdly, there are intermediaries such as lawyers. Now, I think that when people don't give their names, then this will allow the competitors to use this to their advantage to try to strike a blow at their competitors. Now, maybe we can have a second thought about this. Now, in Para 6, the Competition Commission has the discretion to whether to accept these complaints or not. Of course, there are criteria for accepting the complaints or whether to go ahead and investigate. Now, once the decision is made, will there be an appeal mechanism? That is, I don't agree with the way this discretionary power is used by the Commission. Also, there have been news reports recently, like collusion in pricing, some jewelry shops. Now, we know that in the past few decades, they have a gold price fixing every day. Some small jewelry shops feel that if this is not exempted, then the small jewelry shops, well, I can't say they are persecuted, but maybe they will be forced out or phased out under competition because the large shops can furnish a better price. Now, if this is there's a price fixing, now if that's a colluded price and the prices vary, then the small jewelry shops will be impacted more. Ms. Wu, now I will try my best to answer these questions, and if I'm unable to, my colleagues can supplement. Now, on complaints without providing the names, now I think we have the obligation to deal with them, but I understand people's concerns. Now, we also have internal procedures for handling. For instance, when we receive such complaints, we will not start investigation, rush into it right away. We will first try to check and find information in the industry, and we will try to induce whether there are actual grounds, substantive grounds for the complaint before we actually go ahead and investigate further. Now, in this way, we try to prevent abuse of the mechanism. Now, on appeal mechanism, it's mentioned just now that there are so many complaints and some people disagree with our approach, can they appeal? Now, at this stage, I and my colleagues are considering that internally we can have small groups to engage in supplementing work. If there are some issues, and we have small groups to assess whether we want to pursue further. Now, this is has to do with appeal and may not have the effect that Mr. Chung referred to. We will go back and think about it. Third, on the jewelry shop issue. Now, to put it simply, now in the past, this happened with the banking industry too. When I was chairperson of the Consumer Society, we also dealt with the collusion in pricing matter and worked with the banks, and the banks were eventually willing to dismantle this mechanism for fixing time deposit rates. So we will continue to discuss with the jewelry shops to try to allay such concerns. Mr. Chan Kim Po. Now, Chairman, when we discussed the Competition ordinance or bill, we try to ensure whether the objectives can indeed be achieved. Especially, we are concerned about the SMEs. At the time, the insurance industry was most concerned. Now there are labor insurance fraud cases, and we will consider the cost of the claims for the industry, and so for every $100, maybe we have to charge $2. Now this is just for information. Now I think this can continue. Now how do they fix the price? We don't care, but so we will, if we provide this information, this will not be against the competition law. Can we confirm that?
You or Philip would like to take this question?
Hello, thank you. I'm not entirely sure that I understood the honourable member's question. It may be a translation issue.
Yeah, maybe I try to say in English is that we have a share of information. We collect the individual company. They may have some claim statistics which we collect, and then we say that certain kind of line of business would for example, last year we have that kind of total statistic for the claim amount for a certain line of business, and then we distribute this kind of information to the members. But of course we didn't indicate how much we should charge. So is that kind of sharing of information still, sort of not forbidden by this competition bill? That's what I want to clarify.
Okay. I think in general we don't comment in this sort of a public arena on a live case, if you like. But obviously the insurance sector is a sector where it is well known internationally, where certain statistical information has to be exchanged with a view to determining what the price for a particular insurance product might be, and internationally competition law has been able to accommodate that sort of information exchange. And I note that the honourable member has referenced that there was no exchange around premium pricing, so that's obviously an important consideration.
Okay, thank you. 主席啊，我諗就咁樣，即係
Chairman, I think we still have concerns about competition law. I hope that Ms. Wu will be more bold. She shouldn't say that I may not comment on this or that. Now, if there's no impact, then tell us. The system is going to come into effect. Now, maybe when they drop the legislation, the people who drop are more cautious, but you have been a lawyer for many years. You dare to speak. So do try to help us with these gray areas and try to clarify them. So do not be over concerned. Now, I think many industries have similar problems. I hope your organizations will be more bold and spell it out if there's no need. Because when we talk about this compliance cost and it's not clear, and we go and ask a lawyer and the lawyer cannot provide a clear answer. So the compliance cost is a concern for everybody. I get the message. I will consider that.
In the discussion of the competition bill, actually, for quite a long period, we had many exchanges with Anna, and I know that you've done a lot of work before you prepared the guidelines. I had several meetings with you, and the different trades in industry had also submitted their opinions to you. So the guidelines reflect the interpretation of the Commission on the provisions in the ordinance. But then people say the guidelines are the law itself. And the competition tribunal and the courts will have the final say on how to interpret the ordinance. This is a point of concern to many people. Will there be cases that there are gray areas? Well, the guidelines were compiled after you have taken into account views and comments provided by different sectors. Now, ultimately, if there is a problem with the guidelines, say, if the courts don't agree with what is stated in the guidelines, what will happen? This is worrying to many people. People are worried about this. So I hope that within the Competition Commission, please pay attention to this particular point. Now, also, Anne also mentioned about fees. Or do you plan to prepare guidelines on labor issues? Now, well, you should not be allowed to collude to fix prices, and likewise, you should not collude to say in collectively bargaining with your employers. So if the Competition Ordinance commences, it governs not only the prices but also fees as well. So please, Competition Commission, please try to see if you can publish more guidelines to reassure people. There has already been a lot of contention surrounding the ordinance, so please try to issue more guidelines to clarify the situations. Now, first of all, I would like to clarify the guidelines cover all sectors. So we have to be tone it in a way that it is more generalized. But then we can quote more examples to give further clarifications. Now, in other cases, we can give more detailed guidelines or information. For example, for some sectors, they may have unique characteristics, and we have discussed with these sectors, and perhaps we can use other sort of ways, like, say, putting the issues in the form of Q&As, frequently asked questions, to allay people's worries. So this is what we plan to do. So we will look around, and we may do it for some specific sectors, frequently asked questions. Now, second, guidelines are not part of the law, and the court has every power to disagree with the guidelines. And the Competition Tribunal is also empowered to disagree with the guidelines. But then the tribunal has examined international standards in judging cases. So I hope that we can try to sort of narrow our differences in the interpretation of the law between the Competition Commission and Competition Tribunal. But then the Commission must abide by the guidelines we issue. So this is what we are going to do. Second round, Mr. Tan Kah Peel, 2 minutes. Thank you, Chairman. Well, you have made certain responses in relation to workers' collective bargaining power, and you said that it will be very low on the priority in terms of enforcement actions. But you did say two things. You said that the guidelines may not be something that the judges will agree to, and also you said that there have been sort of international best practices. Now, I think case laws may come in here. So, in accordance with case laws, is there any stipulation that there is a division, segregation between labor issue and competition issues, or labor policy and competition policy? Well, places differ in terms of the treatment of labor issues, but then they share something in common. In some places, there is an express exemption for labor issues, but in Hong Kong, we really don't have that specific provisions in our ordinance. But for us, we have to abide by the provisions in the law ordinance when we enforce the law. So we have to look at several factors. One, whether you are in undertaking. Second, are there economic activities, commercial activities involved? If they're not, then they will fall outside the scope of the law. And then we will also look at our policy, whether we would give a priority. And the last factor is that if there are further queries and people come forward for applying for exemption, then we will look at the economic interest involved, public interest involved. So these are the 4 thresholds we will consider when we come to see whether there will be exemption granted to a certain case or issue, like the labor issue. Now, if there is a case law which gives specific directions. So can you, if there is such a case, can you include the information on the case in your guidelines so that would make things clearer for everyone? Okay. First round. There are some members who have not spoken. Well, for fairness purpose, those who haven't spoken for the first time, do you want to speak? Now, if not, then I'll go by the established procedure. Dr. Fernando Zhang, 4 minutes. Chairman, we talked about the possible clashes between labor legislation and competition ordinance. Well, if there is a provision on colluding to price fixing, so under that, should collective bargaining not be allowed? Well, I would like to share my views. The competition ordinance is to create a market level, level playing field in the market, and that there will not be sort of monopolistic behavior, and there will not be people dominating the market and major players with a substantial degree of power abusing their power and so on and so forth. But in the labor policies, we talk about minimum wage and collective bargaining power, and that are aimed at striking a balance between the power and interest of the employers and the employees, so that there is adequate protection for workers. So this is the spirit of the labor legislation. So the spirit behind the 2 sets of legislation is totally different. The focus is different. So I hope that the Competition Commission, please try to understand the difference in the spirit between these 2 sets of legislation. For the labor legislation, we're talking about striking a balance between the interests of the employers and employees, but whereas in the competition ordinance, you're talking about the power, the division of power between the different players. So a worker should be afforded the minimum protection. So I don't think there is any conflict between the 2 sets of legislation. So, Chairman, I agree to what Dr. Zhang said. So, as I said, well, there are several criteria: undertaking, economic or commercial activities, and also the policy. On the policy aspect, we would also take into consideration remarks made by Dr. Zhang. So, as I said, labor issues are in no way the priority of our work, and they fall into 2 different policy portfolios. So I think members have expressed various views from different perspectives. I think after all, it will be up to the Competition Commission to do their work. Hong Kong is a free and open society, and everyone in Hong Kong is entitled to his or her opinion in whatever issues in the community. So I hope, Anna, please take heed of views expressed by members in the meeting, and I hope that members would also note the the draft guidelines published by the Commission. And you will be further consulting the community on the draft guidelines. And after that is done, then you will publish the finalized guidelines. And I would like to thank the representative from the Competition Commission and the Communications Authority Office for being here today. And I hope that you can publish the finalized guidelines as soon as possible. And I hope that in implementing the Competition Ordinance, the Hong Kong's development can be boosted as a whole. Thank you very much, Chairman. We will come back in 2015. Next, AOB. Any AOB? No? Then, meeting adjourned. And we'd like to remind members that the next meeting is not a Monday, it's a Tuesday, the 16th of December in the afternoon. We'll try to start the meeting at 4:30. Thank you.